Can you believe it's already 2024 and it is almost March, and I'm ready to get up close and personal with the 2024 Georgia Association of REALTORS Purchase and Sale Agreement. And I want to go through, this is a 10-page agreement with most of the blanks are going to be on page 1. And I want to go through and fill out an agreement with you so you guys can follow along with me. And I'm just going to chat with you guys based on my own experience and opinions as a broker here in the state of Georgia. And hopefully this information can be helpful to you. And if you're ready, let's go ahead and jump in. And I have logged in. You guys can see my screen. I'm in FMLS. Now, you can get your contract forms in Georgia MLS if you prefer to use the transaction desk. You can go directly to GARealtor.com and you can download all of the contract forms and load them into another forms editor if you want to. A lot of us use FMLS. I teach my classes through FMLS because of Remine, specifically because of Remine Docs Plus. And that's where we're going to go to get the forms today, because it is a smart form editor. It lets you type in the blank and fill out the terms of the contract. And it also has, and I already have a test file here, it also has an e-signature platform built into it. So you can send it out for signatures. You yourself can sign it right here on the screen as the agent before you send it out, which is what I typically would have you guys do. But just know you can get the forms in FMLS, Georgia MLS, or directly from GARealtor.com. The GAR forms are available to realtors through the membership that you pay every year. So you're going to pay around $425 a year here in Georgia for membership. Now that's prorated depending on when in the year that you join, but that does include your access to the GAR contract forms. If you are not a realtor and you want to use the GAR forms, you can visit forms.garealtor.com and you can purchase a license to use the forms for the year. So a lot of agents will do that. Now, if you are wondering, well, I'm a Georgia agent and what happens if I don't want to use the GAR forms, which that's what we're looking at today. This is all about the GAR form. If you want to use a free form, there are RE contract forms out there. So GAR forms and RE forms are the two major set of contract forms in Georgia, but by far, the GAR contract forms are the most popular. They're more easy to use. They do more to protect the parties. They're updated every year, at least once a year. Sometimes there's even mid-year changes that happen. Well, there are mid-year changes that happen. They're not usually major changes. Most of the big changes happen in January. But and I'll do my best to point out some changes that we experienced this past year to the contract forms as well. So, but here we are. So we're face-to-face with the contract. We're in FMLS Remine Docs Plus. I have a test file. You can create test files too, and you can pull in the contract forms. Now, again, when you're pulling in the contract forms, they pull in the smart forms that you can type in already. But if you wanted to pull in a builder contract or another type of contract, you could upload it from your computer. Every file that you make in Remine has its own email address. You can even email it over. A lot of agents with new construction will do that. They'll build their brokerage agreement in here, and then they'll want to keep everything in one file for their own records. They'll email the other documents here. Now, if you have a license to use the GAR forms, you can enter in that NERDS number, that NRDS number in settings. If you have an FPID number, that's a forms purchase ID number, because you purchased a license to use the forms, you'll enter that FPID number in your settings as well. That will allow you to access those contract forms. So, all right, so let's go ahead and get into this contract form. Now, I do want to stress that the MLS hosts a lot of contract forms. Now, FMLS, because of the partnerships that they have developed over the years, if you're an FMLS member, and I love this, we have access to listings in Florida, Alabama, Tennessee, all over the place, right? Even out west. I'm super excited about it. Really enjoy the strides that FMLS has made over the years. But because of that, we are seeing additional contract forms pop up. You'll see Alabama contract forms. You'll even see forms for other parts of the state. So Middle Georgia FMLS has a partnership with Mid Georgia MLS. You will see their agreements in here too. I just say that to caution you to use the same set of contract forms, all GAR forms or all RE forms, and don't accidentally pull an Alabama amendment or listing agreement. It happens. But if we just look at the top right-hand corner of the GAR forms, we will always see the Georgia Realtor logo, and it'll say 2024, so we know we're dealing with the current year. It's also going to reference GAR at the bottom of the pages and also the name of the authorized user. So if you are an authorized user, your name will appear at the bottom of the form. And we should not share these forms. So GAR has terms of use. We can't just pass these forms to other people. The name at the bottom needs to be one of the agents, one of the licensed people involved in that deal, or the form really, it shouldn't be used. So that's different than years ago. There was a time, I know some of you probably remember, when the GAR forms were free and they could be shared with FSBOs even, but that's just hasn't been that way for a minute. So we only want to use the forms when we're involved in the deal. So here we go with that first page. So key terms and conditions. Now keep in mind, this is short and sweet, and I'm going to do my best to keep this moving. But there are 8 other pages of this agreement, or really 7 other pages of the agreement that contain boilerplate language. That's what attorneys call it, and that's the devil's in the details, right? That's the details, is in those 7 other pages. And I cannot stress enough the importance of reading the contract. I tell folks at least 3 times every year, if you're a new agent, probably 5 times before you write your first contract, because it will help you more than I could ever express verbally to you. Answers to frequently asked questions, problems to common issues that come up, the answers are in the contract itself. GAR, and I will say this, I'm now licensed in Florida and in Tennessee. So as the market's been a little bit slower, a lot of us have picked up additional licenses, which has been a lot of fun. But it's interesting to see how other states handle advertising rules or brokerage relationships and even contracts. And I felt for a long time that GAR probably did way more than other states. And I can say that from a contract form standpoint alone, these contract forms are beautiful. And agents will come to me who are licensed in North Carolina or California or who knows where, and they will also say that to me. They're amazed at how easy the GAR forms are to use. They make sense, and I think that's something those of us who are licensed in Georgia have to be proud of. These contracts make sense, and the GAR Forms Committee does an outstanding job. So, and I'm not on the forms committee, so I have no benefit in saying that, just sharing with you my opinion on these forms. And not everybody feels that way, but I think these are great forms. So let's go ahead and jump in. The offer date here is simply the date the offer is being made. So this happens to be a Sunday in February when I'm filming this with you guys, and we're going to pick that date. We live in a world where things move very fast, and so most likely this is going to be the same date that I'm going to send it to my client. They're going to sign it, and may even be the same date we go binding, right? Things move pretty quickly. But the only date or the only thing in the contract that's measured from the offer date is really going to be the time limit of the offer. So the offer date's not going to have it's a point of reference, but we're not going to have a whole lot to do with it other than measuring the time limit of the offer from it. But that's how we start off this offer. Then we jump straight into key terms and conditions. And there's 2 ways that we have to identify the property. One is the commonly known mailing address, and then secondly is going to be the legal description. Now, MLS number if applicable. If it's a FSBO, it's not listed. You don't have to fill it in, of course. You could put in A for not applicable. And then the tax parcel ID number. Want to encourage you to go ahead and put that in there. Now, the mailing address is not enough. We want to do everything that we can to ensure enforceability of this contract. There is no guarantee that this contract would be considered enforceable by a court if it didn't have a legal description. And also, you guys, it's in our license law in Georgia. Our license law here says that we will include a legal description of the property in the sale contract. So we are faced with that here in 1B. And there are 4 different ways that we can include that legal description. So let's talk about those for a second. One is we can attach a copy of the legal description. That would most commonly be a deed to the property. So a deed to a property is going to contain a meets and bounds, which is the legal description for real property here in Georgia. So that's an easy way. Maybe it's a survey or whatnot, but typically that's going to be a copy of the deed. Now, if you have access to the gsccca.org website, you could pull a copy of the seller's deed there and attach it. Maybe the listing agent obtained a copy from the seller when they listed the property and they already have it. Maybe they added it to the documents of that listing in FMLS. Super easy to do and very helpful. You could pull that and use that. But condominium, if it's a condominium, GAR does direct us to use the condo purchase and sale exhibit for a resale. That will include blanks for a legal description as well as some helpful disclosures to the parties. Number 3, I already have it checked because it's the most common and the easiest, to be honest. And that's because in the tax records, particularly in realist here in FMLS, you're going to see last market and sale history. If you scroll down and look at that property page, and it will reference the deed book and the page number to the property. We're typically going to pull the most recent deed book and page number, and you can simply fill that in, and that is perfect. Now, number 4 is the one that I will see the most mistakes with and the one that I would try to stay away from, and that is because we really need the plat book and the page number. If we're going to go with number 4, we need the plat book and the page number, and most of the time when I see agents choose 4, they may know 1, maybe 2 of the options here, and that's just not going to be enough. So most cases, number 3 is going to be your winner. But at the end of the day, you want to have a legal description or a key in the contracts that you complete and the offers that you make. Now, let's talk about the offer price. Purchase price is going to be the price that the buyer is offering to purchase the property. Now, the average sales price here in Atlanta, Greater Atlanta right now, is around $530,000. Can you believe that? So that's what we're going to fill in number 2 is the price the buyer is going to make. Now, the buyer will likely want to look at comparable properties that have sold, and as a buyer's agent, there's value in a CMA from a buyer's agent standpoint, just like there is from a listing agent standpoint. So that information will be available to you in the MLS as well. So really important to review that with the buyer. And then in number 3 is going to be the closing cost contribution. Now, negotiating is back. We're seeing it come back. We're seeing more sellers pay some in closing costs. And this is where that would be identified here. Now, this is the seller's contribution toward the buyer's closing costs. Now, it is generally a good idea to check with the lender on a couple of things, including what the cap would be with any seller paid closing costs. Because let's just say that we asked for $20,000 in closing costs, but the buyer's actual closing costs were really only $10,000. That extra $10,000 would remain the property of the seller per the boilerplate language of this agreement. It wouldn't be a check to the buyer at closing. The buyer would not get any credit for those additional funds. So that is something just to keep in mind. Now, closing date and possession. So most deals are going to be financed deals. Now, if this is cash, how fast can the closing attorney close this? When do the parties want to close? Those would be the kind of questions we would be looking at. But a finance deal is typically going to be 40 to 45 days. A little bit of a cushion, certainly not going to hurt anything. when it comes to picking a closing date, see, I love the fact that FMLS lets us look at a calendar. I typically stay away from Fridays and Mondays. Definitely Fridays, because if by some chance the closing doesn't happen on Friday, the parties have Saturday and Sunday, and that can feel like eternity for them. And then Mondays can be busy days as well. So kind of my sweet spot and recommendation is to stay within a Tuesday to Thursday time frame. And I'm not even doing the math here, you guys. I'm just going to pick something just to give you an example of a closing date filled in here in this section. Now, I am a huge fan of possession being provided at the closing. Buyers moving in early, sellers staying in properties after, and there is a temporary occupancy agreement. There's one for buyers and there's one for sellers that GAR has, and that's the most protection that we can give the parties, right, is to use that temporary occupancy agreement when that is what the parties want to do. My advice would be to try to keep things as simple as possible, try to avoid disputes as much as possible. That's kind of my theme when I'm helping you guys with these contracts, and because it does create more risk, right, when a buyer's moving in a property early and when a seller's staying later. It just does. So I have found over the years that it's actually less painful for the parties to just move the closing date than to try to include temporary occupancy. But that's my recommendation. If it is going to be temporary occupancy, just make sure those forms are used so the parties have as much protection as possible. Now let's talk about the closing attorney. So here in the state of Georgia, a closing attorney is required to close a real estate transaction. That's not true in every state. In Florida and in Tennessee, while a closing attorney could close the deal, you will see title companies closing deals. But in Georgia, it does need to be a closing attorney. And it gives us two sections here. We have the phone number for the attorney and also the name of the attorney. Now, a lot of attorneys will have multiple locations, so feel free to go ahead and specify which office location that's going to be. It may not be such a big deal because a lot of attorneys will tell us that they can close a buyer in Alpharetta and a seller in Decatur. They don't have to be in the same physical location, but it is wise to go ahead and specify which location you guys are proposing to close at. Holder of earnest money. Wow. So this can be kind of a big deal. So 6 and 7, who's going to hold the earnest money? And then what are the details of the earnest money actually going to be? So here in Georgia, it is increasingly common for closing attorneys to hold earnest money. And as a real estate broker, now the brokers can hold it. Buyer's broker, seller's broker. A little bit more common for a seller's broker, just historically, to hold the funds. Earnest money, good faith deposit, whatever you want to call it. The more a buyer is willing to pay, the more confidence they are showing in their offer. It's money held in escrow to help ensure the performance of the parties. While it's technically not a legal requirement in Georgia, it is very much so recommended. I would not recommend a seller to accept a contract without earnest money. And I really wouldn't recommend a buyer make an offer without earnest money. Now, there may be some exceptions to that. Maybe it's a cash deal that's going to close in 7 days and everybody feels good with it. But earnest money is the seller's sole remedy in the event of buyer default. So if the deal fails to close, seller only has the earnest money to go after. So the parties are agreeing that is liquidated damages. So definitely recommend earnest money, and I actually recommend the closing attorney to hold it. And that does mean we would need to include F510. Yes, it means the closing attorney needs to complete F511. These are not difficult forms to fill out. These are super easy to fill out. But if there are issues, the parties tend to respect the decision of the closing attorney more so than a broker who is most oftentimes representing as a client one of the parties in the transaction. Now, there is one instance where I do not recommend the closing attorney to hold the earnest money, and that is if it is a cash deal, because the closing attorney represents the lender, But if it's a cash deal, per the contract, they represent the buyer. And per the terms of F510 and F511, if it's a cash deal and there's an issue with the earnest money, let's say, and the parties are disputing the earnest money, the closing attorney is going to interplead those funds. That's a lawsuit, right? So interpleading is not really where we want to go. In most cases, the majority of the earnest money may be completely eaten up in that lawsuit. So in a normal situation, if it's not a cash deal, then the holder of the earnest money, they have the authority to issue what we call a 10-day letter, meaning if a deal doesn't close and the parties are disputing the earnest money, they can review the contract, the details of what happened, and they can make a decision as to who's going to receive the money and issue a 10-day letter letting everybody know what they intend to do with those funds. Now, the holder of earnest money also has the duty to notify everyone if the funds aren't timely turned in, or if the funds bounce, the funds don't clear. There's a step-by-step process in this contract for that. It's not a case of the earnest money wasn't turned in, the earnest money bounced, my seller can automatically terminate, right? That is not the case. So that's step-by-step in this contract, what needs to happen. The first thing that would happen is the holder needs to notify everybody, and the buyer has 3 banking days to what we call cure the default first, before the seller has 7 days to terminate. So that's a little bit beyond the basics of what we're chatting about here on page 1, but you want a holder that's responsible, right? And when it is the closing attorney, F510, they're agreeing to perform those, or F511 rather, they're agreeing to perform those duties. All right, enough about earnest money, you guys, but it's super important. Number 7 is the amount and when the funds are due. So B is going to be the option that I'm going to recommend almost every single time. If we choose A, that means the money needs to already be in the holder's account. They need to already have that money turned in to the holder. In B, the amount and when the funds are due. Now, there's no right or wrong. Again, the more earnest money, the more confidence the buyer is showing in their offer. But the reality is 1% to 2%, 1% is pretty common. That's pretty much what you're going to see. So I would expect with this offer price to have $5,000 in earnest money turned in. There are cases where it may be a little more, and there are cases when it may be a little less, but around 1% is what you're going to see in most cases. And within 2 to 3 days from the binding agreement date. That means if the offer is not accepted and notice of acceptance doesn't happen, we don't become binding. If we're not binding, the buyer's not out the money, right? But if we become binding, the buyer has a time frame to turn in those funds. Now, the GAR Forms Committee does give us C, if there happens to be a special circumstance where we need to specify something special when it comes to earnest money, but usually that's not the case. Usually earnest money is pretty straightforward here in 7B, and that's going to be the option that is usually going to work for us. Now, moving on to number 8 here, which is inspection and due diligence. So here in the state of Georgia, Georgia is very much so a buyer beware state. So a buyer is expected to perform their own, what we call due diligence. Have a professional home inspection, pest inspection, survey. Surveys are wildly underutilized and they're so important. Anything and everything that could impact a buyer's desire to move forward with purchasing the property. Maybe they want a specific school zone, or maybe they want whatever it is that means that's very important to that buyer. If they haven't already looked into it before they're placing the offer and going under contract, due diligence is that opportunity to do that, because a buyer can terminate for any reason at all during that due diligence period. Outside of due diligence, they may have financing and appraisal and whatnot, but for any reason at all is limited to that due diligence period. And I know we've been talking about how this GAR contract is a fill-in-the-blank contract. It's customized. We're customizing the agreement by filling in the blanks. We're also customizing it with exhibits and special stipulations if we need them. Things like financing and appraisal, those are, with the GAR forms, those are always going to be exhibits. So the GAR form is typically customized through exhibits. use special stipulations sparingly would be my recommendation for sure. Now, due diligence period in the market that we're in today, typically 5 days. 7 would be on the high side right now, in contrast to when we were back in a buyer's market. And we were chatting about annual contract forms. If you look back at some of those videos, you'll hear me talk about 12 to 14 days. That seems like an eternity ago. Now we're in a time frame where 5 to 7 is considered a win when you're with the buyer. But most home inspectors can move really quickly. And so that's important too, is to have professionals on your side who can move fast, because we're still in that competitive market. So you want to get that inspection report back, have an opportunity to review it, have an opportunity to try to negotiate any repairs or price reductions, because once that 5th day expires, the buyer is moving forward, purchasing the property as is. Doesn't mean the seller couldn't later agree to an amendment to do something, but there's certainly no guarantee of that. There's no guarantee of it even during due diligence. But again, that right to unilaterally terminate for any reason at all is just limited to that due diligence period. Now, option payment for due diligence period. This is not common in Georgia, but it's here. And in certain competitive situations, we may see it used more. But this would be literally the buyer paying the seller for the due diligence period. And let's talk about, usually you're going to leave this blank, but when I would see it is that the buyer's asking for an unusually lengthy due diligence period. Let's just say that the buyer is looking for 25 days due diligence. Then I might see some additional funds being paid to the seller in exchange for that extended option period of time. And there's no magic number for this, but typically the longer period of time the buyer's asking for, the more option money you're going to see there. The thing to understand about option money, and typically there is earnest money and option money. You could all just be option money, but I wouldn't recommend that. Typically you're going to see a little extra money, maybe $500, $1,000 extra paid. Again, completely depends on how much time you're asking for the due diligence period when it's a little bit longer. But important to keep in mind, if it is ever used, is it's funds paid directly to the seller, and it is non-refundable. So it's paid directly to a seller. It's non-refundable. It may or may not be applied toward their purchase. I would definitely recommend that it shall be applied toward the purchase, but that is optional here. You have 2 boxes to select. Now, moving on from due diligence and option money, we have lead-based paint. If the property was built prior to 1978 or any portion, we are required. It's a federal requirement, EPA requirement, that we include a lead-based paint exhibit. The buyer needs to receive a pamphlet, and we need a completed lead-based paint exhibit. So if you're listing a property that was, we're going to call it a target property because that's what EPA calls it, go ahead and have the seller fill out that lead-based paint exhibit when you take the listing and attach it to that listing in FMLS. You will be a hero to a buyer's agent, because one of the worst things we can go through as a buyer's agent is to be working with a target property and not have that lead-based paint exhibit. And you want that readily available to buyers and their agents so they can include that when they make the offer. And we're almost done with the first page, you guys. I know I ramble a bit with these, but there's so much information to chat about when we're filling out these blanks, because we're not going through the additional pages. I'm kind of just giving you guys the feedback as we go through these, but we're almost there. But in number 10, we're looking at brokerage relationships. So we're going to identify the broker involved in the transaction and working with the buyer and what their relationship with that buyer is. Same thing on the seller side. If a property is listed in FMLS, we can safely, I'm going to use the word assume, I'm hesitant to use that word, but we can safely assume that there is a client relationship with between the listing broker, the seller's broker, and the seller. And the reason why I say that is because per FMLS, Georgia MLS rules as well, there must be an exclusive brokerage engagement agreement, an exclusive right to sell listing agreement in place before we can list the property in the MLS. That's true even for your own property. So if you're an agent and you're listing your own property, you need a listing agreement between you, because the brokerage agreements are through the brokerage. You would need that. You're going to be signing that most likely as the agent and as the principal, but you would need to have that in place. So that's why I tell you guys we can safely pick B1 if it's listed in the MLS. It's because we know if they're following the rules, there would have to be a brokerage agreement. And our brokerage agreements in Georgia, they also create, because the language that's baked into them, they also create that client relationship. Not all state forms do that, but in Georgia, ours do. Now in 10A is the buyer's broker. Identify who the brokerage firm is working with the buyer and what that relationship is. So again, client relationship, if there's a written brokerage engagement. Because of BRETA, here in Georgia we have BRETA, that stands for Brokerage Relationships in Real Estate Transactions Act. And it does a lot of great things for us in the industry, but one thing it does is it overrides common law of agency, and it says a party is only a client if they have signed a written brokerage engagement agreement. So if you have a written agreement with them that establishes that client relationship, you can comfortably select number one. By default, if you don't, they are a customer. Nothing wrong with working with a party as a customer. We are limited to only ministerial tasks for customers. So typically, once we explain, and GAR has a wonderful pamphlet. It's called the ABCs of Agency. If a buyer, anyone, reviews the ABCs of Agency, a common vibe after reviewing it is I really do want that client relationship. I want advice and counsel throughout the transaction. I'm not looking for just a paper pusher. Some people are, and again, there's nothing wrong with that. Representation and compensation are two entirely different things. I know that, again, that's getting a little bit outside what we're talking about today and just going over these blanks. But whatever that relationship is needs to be established before the offer is made, so this can be accurate. Most of the time, it's going to be that client relationship. Now, number 3, dual agency and then also designated. So dual agency, at least in Georgia, is if the same agent has a client relationship with both parties. So one agent and a client relationship with both parties. That's not very common. Designated agency, on the other hand, is when the same real estate company, the same brokerage firm is involved, and there is a client relationship with both parties through the brokerage, but both parties have a specific agent they're working with. So in Georgia, designated agency is more of a default situation, but it would be the same brokerage firm, state license number on both sides of the transaction, client relationship on both sides, but there's two specific agents of that firm who are working with each party, and you could specifically set forth the name of that agent here in Section 4 if that were the actual case. Now, when it comes to material relationships, if there is a material relationship, if you know that party outside of this transaction in such a way that could impact negotiations in the transaction, it would need to be disclosed here. Maybe your agent is principal. This is a really convenient place to go ahead and disclose that. Maybe you're an agent and you are a part of the purchasing entity. Maybe it's an LLC or a corporation. You still need to disclose it, that you are a member of that buying entity. This is a perfect place. You could use special stipulations, but this is the most appropriate place, in my opinion, to go ahead and disclose that. Now, in number 11, we're looking at the time limit of the offer. A reasonable time limit is what you're going to hear me recommend, and that could be anywhere from 2 to 3 days. Maybe the seller's on a cruise, and if we happen to know that, maybe we do want to give the offer a little bit more time. If we don't include an offer time limit, then the offer would be considered open for a reasonable period of time, which is not an identified period of time. A lot of attorneys will say it's considered to be a year. But who wants to leave anything open for chance? Again, we're trying to lock these contracts down in such a way to where they're not ambiguous. We're not leaving anything open for future negotiations if we can possibly avoid it. So a reasonable time limit is what I'm going to recommend for you guys. Now, when it comes to initials, there's a section for initials to be on the first page of the GAR form. I'm going to encourage you, of course, to go ahead and fill those in to ensure that the parties have thoroughly reviewed the information here on the very first page. Okay, so that was a lot of information, right? I feel like I sped through that information, but that was the first page of the GAR contract. So again, these are the key terms and conditions. They correspond with the boilerplate language, the additional paragraphs, which have a lot of information, way more information even than I'm sharing with you, contained in them. And this agreement's customized through filling in the blanks, through special stipulations, and through exhibits. Exhibits are the big ones because that's where your financing and appraisal, the appraisal contingencies are baked into the financing exhibits. Special stipulations, going to encourage you to use those sparingly. So at this point, what I'm going to do is I'm going to casually scroll to the special stipulations page, and I'm going to point out just a couple. Again, I'm not going to read it all to you, even though I'm going to encourage you to do it, but I'm going to point out just a couple of things as we make our way to exhibits and special stipulations. And the first one that I'm going to stop and pause at a little bit may surprise you because I want to talk to you about leases, because things kind of come in waves. I'll get questions in waves as a broker, and right now there's a little bit of a wave about investment properties and purchasing properties that are leased. And the question will come to me, well, as a buyer's agent, what do I need to do differently if I'm putting together an offer and there's a lease on the property that doesn't expire for a year, right? Do I just need to ask for the lease during the due diligence period? No, that's not all we need to do. That's a great thing to do, to ask for the lease during the due diligence period. But knowing this contract really, really well, and this is why I really encourage everybody to read these contracts, because the more you know these contracts like the back of your hand, when unique situations pop up, you're going to more easily be able to figure out what to do. Yeah, of course, you have your broker that you work for to chat with as well if you're an agent, but you're going to have a lot more confidence and really know how to move forward, because what the contract basically says is that this is talking about what's going to happen at closing. It specifically says that the property will be conveyed at closing free of any leases unless they're specified in this agreement. So we need to specify that the property will be conveyed at closing subject to a written lease agreement between dated such a date. We're going to make it nice and tidy, but we're going to specify very clearly in the offer that the property will be sold subject to an existing lease. Now, is it wise to also ask for a copy of the lease within so many days of binding? Yes. Is it wise to use the GAR special stipulation? GAR has a special stipulations library that attorneys wrote for us, and one of those special stipulations is regarding the proration of rent, the transfer of security deposit. You see, there's different things here that need to be thought through, but including that special stipulation, specifying that the property is being sold subject to a lease, requiring a copy of the leases within so many days, those are just a handful of things that I would recommend. So it's so much more than just, hey, can I get a copy of the lease during the due diligence period? Because those leases are binding on the owner when they close. So that buyer, when they close, those leases, they've inherited them. So possession and closing. So when it comes to possession and closing, there is a 8-day unilateral right to extend the closing date that is unique to the GAR contract form. The RE contract forms, new construction forms, you're not going to see it there. And it allows a party, buyer or the seller, under certain circumstances, and it's actually only a few circumstances, to unilaterally extend the closing by 8 days upon written notice to the other party. So if an 8-day extension is going to be used, it needs to be exercised on or before the current date, and it does push it out 8 days. The circumstances that would apply are set forth right here in the contract, and there's only just a few. And it's not because it shouldn't be used because the buyer failed to do something. If the closing attorney is delayed, the lender's delayed, and it's not the buyer's fault, then that would be a legitimate reason to extend it. But if we're on vacation or a family event came up and we just want to move the closing, that is not a contractual right. So, we talked about earnest money. If earnest money is not timely turned in, holder needs to provide notice. Buyer has 3 banking days to cure the default. It talks about 10-day letter, all those things. Talks about interpleader, hold harmless. The time limit of the offer itself is an offer can be accepted, rejected, it can expire. If a buyer makes an offer and they want to withdraw it, there is a form that GAR has to formally withdraw that offer. An offer can be withdrawn at any time before it is accepted. An offer can be accepted even after the time limit expires. It's just generally considered a counteroffer, which means that the other party could either accept it and you guys could choose to move forward or not. Default. Oh my goodness. So what are my clients' options? What are my customers' options if the other party fails to close? So we're not trying to be attorneys, right? But one cool thing about the GAR forms is they really put it all out on the table in very clear terms right here under the default section. So one thing I like to do is just encourage everyone to refer the customer or client to the default section of the contract. It will include the remedies of the parties. Damage to a property. If the property is destroyed or substantially destroyed prior to closing, there's a remedy and steps are set forth right here within the agreement. Condemnation. Remedy is set up. FERPTA. Are additional taxes going to apply? Need to talk to a tax accountant. If you're a non-resident of Georgia, non-U.S. citizen, closing on property. Important things to keep in mind. Rules for interpreting the agreement. Handwritten changes, control over pre-typed. Exhibits, control over the main body. And special stipulations control, which is where we're headed, you guys. Special stipulations control over everything else except for the amendatory clause language that is baked into the FHA or VA appraisal contingency. I have talked so much about appraisal gap clauses and escalation clauses, and I'm not the biggest fan of them in the past. I'm going to spare you guys, but if you're interested in conversations about that or examples of this kinds of special stipulations to avoid, they're here on the channel, and you guys can check those out. But when it comes to exhibits, so again, maybe it's a finance exhibit, pretty common. We're going to go ahead and mark that. We're going to go ahead and give it a letter of the alphabet. Exhibits, we're going to go ahead and give it a letter of the alphabet. Exhibits are alphabetical and amendments are numerical. Seller's property disclosure statement, if one has been provided, it's a good idea to go ahead and include that as an exhibit to the contract. Now, because Georgia is such a buyer beware state, sellers are only required to disclose latent or hidden defects. Agents are only required to disclose adverse material facts. So important for buyers to perform their own due diligence. If there are going to be special stipulations, and I really encourage you guys to use this sparingly, I encourage you to look at the GAR forms library for special stipulations first. If there are going to be multiple special stipulations, number them 1, 2, 3, 4 for ease of reference later on. And always better to use one that the GAR Forms Committee has provided, or check with maybe your broker or an attorney regarding special stipulations. Because if all else fails and we're left to draft our own special stipulation, who, what, when, what if, there are certain things, a certain formula that we'll try to use with special stipulations. And there are a lot of great clues in the special stipulations that the GAR Forms Committee has available. So a lot of times we will look at how those are structured if we do need to create something custom, and when possible, have that reviewed and approved by an attorney. So now on the last page, this is the signature page. So we've really gone through all of the blanks at this point. So obviously the parties are going to sign off on this. It's going to list their printed names. You're going to include their contact information, especially if they're a customer. You are required to include your license number, your name, the license number of the company that you work for, its name. Go ahead and include email address, phone number. Include information for you, because the other agent, if there is another agent involved in the deal or one of the parties, they need a formal means of communicating with you. And fax is pretty obsolete. Most people are using email, which is deemed received when it's sent. And the most important date in the purchase and sale agreement is the binding agreement date. And this is the date that the offer has been, or the counter offer has been accepted without change, and notice has been given to the other party. And it doesn't matter who fills in this date, as long as the date is accurate. And if it's not accurate and someone's disputing that, there's only 1 day to raise their hand per the boilerplate language of the contract and try to work out a confirmation as to what that date actually is. But usually that's not an issue. Again, emails are considered received once they're sent. Things happen pretty quickly, and that's what starts the time frame. So for example, let's say you go binding on the 1st, and the earnest money is due within 2 days. The binding date is day 0. The next day would be considered day 1 for counting purposes. So the earnest money would be due by the end of the day on the 3rd if you went binding on the 1st and you had 2 days to turn it in. This contract form, pretty user-friendly. Hope that this was helpful. This is the resale purchase and sale agreement. Again, if it's new construction, if it's land or a lot or commercial, there will be other contract forms that will be the most appropriate ones to use.